Well, ladies and gentlemen, welcome. On behalf of the members of Michael Kirby Chambers, I thank you for all attending. I thank Curtin Law School for providing this venue, which you'll all agree is a very pleasant icon of early Western Australian colonial architecture. I welcome to Perth the Honourable Michael Kirby, a companion of the Order of Australia and a companion of the Orders of St Michael and St George, the Orders of Michael and St George. And I thank him for making the trip to Perth to formally open the chambers in Perth which bear his name. And we hope that he will survive the day. I had the misfortune to miss this morning's event, but I gather it was a very lengthy speech and we have more work for him to do. I acknowledge other distinguished guests, the Honourable Peter Quinlan, Chief Justice of the Supreme Court of Western Australia, the Honourable Justice Jackson of the Federal Court of Australia, Justice Janine Pritchard, President of the State Administrative Tribunal, Professor Harleen Hayne, Vice-Chancellor of Curtin University, Joshua Thompson, SC, the Solicitor General, Senator Fatima Payman, the Honourable Fred Chaney, AO, Simon Millman, MLA, Professor Natalie Skeed, the Dean of the University of Western Australia Law School, Robert Cunningham, the Dean of Curtin Law School. I also acknowledge a number who've made a point of apologising for not being able to be here. Justices Craig Colvin and Katrina Banks-Smith of the Federal Court, Justice Solomon of the Supreme Court of Western Australia, Chief Judge Wager of the District Court, who's on circuit, and Judge Hilton Quayle, the President of the Children's Court, John Fiocco, the Chair of the Legal Practice Board, and Claire Thompson, the President of the Women Lawyers of Western Australia. We acknowledge that today, the 9th of August, is the United Nations Day of the World's Indigenous Peoples, which was established to raise awareness and protect the rights of the world's Indigenous population and to recognise their achievements and contributions to make the world an improved place. It's also acknowledged that this event is taking place on Whadjuk Noongar Budja and respect is paid to Whadjuk Noongar leaders, past, present and emerging. As Chief Justice French AC said at the 50th anniversary of Francis Burt Chambers in 2012, to speak of the bar as an institution is to speak of an abstraction expressed as a metaphor. The concept of chambers is also in that category. It's more than what John Baston, SC as he then was, said to me many years ago, that he really conceived of chambers as no more than a place where one threw one's briefcase in a corner after attending a day in court. But we at Michael Kirby Chambers don't see chambers as a place. The members of Michael Kirby Chambers, like those barristers practising under the name of Michael Kirby Chambers in both Tasmania and South Australia, are unified by a collegiate relationship of mutual trust and an aspiration to practice in a manner which reflects the standards set by the Chamber's namesake in their service to the law and their protection of the fundamental human rights which we all enjoy. The members of Michael Kirby Chambers in Western Australia comprise 6 members present who agreed to form the Chambers in June 2020. It's taken this long, of course, to get our patron across because of matters which I won't go into. All members of the Chambers at the time of being formed had established practices at the bar, preceded by practice in the amalgam. John Brooksby was first admitted to practice in the United Kingdom in 1972 and he joined the bar in 2011. I was admitted to practice in WA in 1976 and joined the WA bar in 1993. David Childs was admitted to practice in WA in 1979 and joined the WA bar in 2004. Noel Hosson was admitted to practice in WA in 1982 and joined the WA bar in 2008. Brian Nuguela was admitted to practice in WA in 1992 and joined the WA bar in 2007. and David Howlett was admitted to practice in WA in 1997 and joined the WA Bar in 2006. And if you want to know anything more about our practices, you can go to our Chambers website. The Chambers are based on a model which keeps overheads to a minimum, enabling members maximum flexibility in their practices, and in some cases, and particularly mine, enabling a capacity to engage in extensive pro bono work. The physical placement of the Chambers is in a serviced office space at level 27 St Martin's Tower at 44 St George's Terrace, which of course is across the road from the David Malcolm Justice Centre and is adjacent to the Supreme Court Gardens, where the Court of Appeal, of course, is now situated. The establishment of Michael Kirby Chambers in Western Australia should be seen in the context of the Western Australian Bar originating as a separate institution in 1962 from legal practitioners practising in WA as both barristers and solicitors when Francis Burt and a small group set up Bar Chambers. That has now evolved to be named Francis Burt Chambers in 1997 and currently has 140 members. Over time, other sets of chambers have been established in WA, and there are now 10 other sets of chambers of varying sizes. Members of these chambers take on board the responsibility they have in practising under the banner of Michael Kirby Chambers to emulate the high ethical standards which have been and continue to be reflected in the work of the Honourable Michael Kirby AC CMG as an eminent jurist of national and international standing, with an enviable record of service to the law and the protection of fundamental human rights. Members of Chambers are guided in the practice of law by his unswerving respect for the rule of law and the pursuit of justice and equality before the law for all. The barristers practising in Michael Kirby Chambers in Western Australia have chosen as the symbol of its chambers the long shadow of its namesake, Michael Kirby, signifying his influence upon the development of the law over his lengthy career. We take as our inspiration in our practice of the law his consistent vigilance in his analysis of the law to ensure that, as he has said, the legal decision-making process does not proceed on the pretence that the solutions to all of the complex problems of the law today, unresolved by incontestably clear and applicable texts, can be answered by the application of nothing more than purely verbal reasoning and strict logic to words, and must take into account emotions of ordinary citizens. We invite Michael Kirby now to formally open the chambers.
Thank you very much, Greg McIntyre, for that welcome. It's wonderful to be here. It's been a day that is most gruelling. I have been punished by the profession in Western Australia, and the chief offender is Brian Nagawala, who's sitting there. I found that if I ever so foolishly responded to an email of his, I would receive a torrent of emails in reply, but he has been most assiduous with the day, and he's kept me busy, and I go out tonight on the midnight flight from Perth with many memories and shining lights from Western Australia in my memory. Chief Justice, judges of the courts of Western Australia and the Federal Court, and colleagues in the law, members of Michael Kirby Chambers, MKC, my job is twofold. First, to formally open the chambers, and I will do that after the second task is completed, which is to reflect a little on the fabulous life of Sir Gerard Brennan, who was a most extraordinary man, a good friend of mine, Chief Justice of the High Court of Australia, the principal author of the Mabo decision, and a true believer in the fundamental dignity and human rights of all people, particularly of the Indigenous people of our country who have been neglected in the past. Sir Gerard was born in 1927 in Queensland, in Rockhampton, and he was a person. He went to the Rockhampton Christian Brothers College, and then subsequently to the Downlands College in Toowoomba in Queensland, a most beautiful place. If you haven't been there, it is really a lovely part of Australia and of Queensland. His father had been a judge of the Supreme Court of Queensland, and it was natural that Gerard, who was very proud of his father, should enter the legal profession. So he went to the T.C. Burns School of Law in the University of Queensland and did his legal studies there. For a time, he was associate to his father in the Supreme Court of Queensland, and he learned many things from his father, but particularly he learned, as he explained it himself, growing up in a united, happy and Catholic family. His life cannot be entirely separated from his religious beliefs, and he was an embodiment of a truly loving Christian family. I myself was brought up in a truly loving Protestant family, and we often had very amusing conversations because of our different starting points in the Roman Catholic Church and, in my case, in the Anglican Church in Sydney. And those of you over here in Perth probably don't know it, but the Anglican Church of Sydney is a little bit like the Baptists. It is a very Protestant, very simple, no Jesus on the cross, the risen Lord symbolised by the empty cross, and that was how I was brought up. So how we would have a little dig at each other about our religious upbringing, but it was always in good spirits, and both of us were very fortunate to have an upbringing in religious faith, which is something I have never turned my back on, and he certainly never turned his back on. During the Second World War, he began two things. First, he became an associate to Justice Kenneth Townley. Justice Townley was a judge of the Supreme Court of Queensland, but interestingly, he became the judge who took responsibility for war crimes trials. Not many Australians today know of that chapter in the history of Australian justice, of the establishment of the war crimes tribunals of Australia under federal legislation to try the Japanese military who were charged with very serious and cruel acts towards the Australians who fell into their hands. It was a rather unpleasant duty to conduct those trials, and there is a wonderful book published by Curtin University academics which reflects upon the war crimes trials, and it's, if I can say so, having launched it over here years ago, it's unputdownable. It's a very readable story of a very sad chapter and of the courage of the Australians, the Australian soldiers, and of the Australian lawyers who took part in the war crimes trials, including Justice Townley. This day last week, I took part in an interesting conference organised in Brisbane by Stephen Keim, SC, who is going to take part later this afternoon in a dialogue. That conference was about the centenary of the law to reform the Crimes Act code in Queensland, which is basically the same as the code that is shared in Western Australia and in the Northern Territory of Australia. It was the first jurisdiction in the British Empire that completely abolished capital punishment. So Justice Townley had the difficult task of presiding in a tribunal which had a death sentence for the most egregious cases coming from Queensland, which by that stage had already had 25 years of the abolition of the death penalty. It was painful and difficult for him and for his young associate, Gerard Brennan, who was working with him. Gerard Brennan then went to the university, became very involved in university politics and university student politics, and he ultimately became a life member of the National Union of Australian University Students, which is an honour that was conferred on me over here in Perth at a conference. The plotting and planning of my assumption of that high office in succession to Sir Gerard is such a shocking story that I cannot tell you about it, but it is something he was proud of and that I am proud of. And in a sense, we were both children of that era, the Menzies, Commonwealth scholarships, and the opportunity to pursue university education. And Gerard Brennan was an outstanding student, a good associate to his judge, and then he went to the bar in Queensland, and he says that he was the first person to jump the divide. Now, this was a reference to something that I was extremely sensitive to, and this was the fact that in Queensland, I'm sure it was never this way in New South Wales, and I'm certain it was never this way in Perth, where Catholic firms of lawyers would not brief Protestants at the bar, and Protestant firms of lawyers would not brief Catholics. And that was a sign of the sort of the downside of the passionate attachment to your own denomination, about which you normally yourself had very little say. I mean, it being selected by your family. But Gerard Brennan had an interesting career as a barrister. He appeared in a great royal commission in Fiji, which was headed by Lord Denning, and he had many wonderful stories about Lord Denning. He then went to other activities, big trials, important cases, and he was an expert in the criminal law. And that's not the usual path for elevation to the appellate courts and the High Court of Australia, but he subsequently became one of the original commissioners of the Australian Law Reform Commission, of which I was the original chairman. And I have on my wall in my chambers in Sydney, exactly near my shoulder, the photograph of those original commissioners, who included Gareth Evans, later Gareth Evans QC, and a very fine Minister for External Affairs and worker for the United Nations. Professor Alex Castles, the first writer of a history of Australian lawyers from an Australian point of view, an Australian legal history, and John Cain, who was a solicitor in Victoria, who went on to become the Premier of Victoria. And so we were an interesting group of people. I often felt that Gerard, who was introduced to me a few weeks after my appointment, was sent to me by the Attorney General's Department just to keep a look on, an eye on this young lawyer from Sydney. But he impressed me from the beginning in two respects, and they really explain the dichotomy that existed in his life. On the one hand, his strong sense of moral values and purpose and in the law, and secondly, his strong commitment to the rule of law, to the independence of judges, and to integrity in judicial office. I still remember in our office in Sydney when a question would arise in a case, in a matter that the Law Reform Commission was investigating, that did or might soon or might someday come before him as a judge. And when that happened, he didn't simply close his mind and close his ears and say nothing, which is what most judges would do. He would immediately leap to his feet and leave the room. He had a strong sense in the integrity of the judges and that they should not be in situations that might subsequently impinge on their impartiality and on their integrity. He truly valued and cherished the integrity of the judicial office. So he was a great barrister. He became a great judge of the Federal Court, originally the Commonwealth Industrial Court and then the Federal Court. And later in 1983, he was appointed by Malcolm Fraser to the High Court of Australia and became a justice of that court, where he did his extremely important work, especially in relation to Indigenous Australians. I should at the start have acknowledged the Indigenous people of Australia. When I flew over here last night, I looked down and I saw the little specks of light coming across the continent and thought of the people of this country who were Indigenous to the country, the First Nations people, who in my lifetime, in my youth, in my university days, had been basically ignored and disadvantaged. And the turnabout and the change in that had a lot to do with Gerard Brennan. He wrote the Mabo decision, and when he had his official portrait taken in the High Court, and you can see it in the No. 2 Court in Canberra, he has one book in his hand, and it is volume 175 of the Commonwealth Law Reports, the Mabo decision. And the Mabo decision was, if he had done nothing else, his greatest legacy to Australia. I could have myself written the dissent in that case. I became quite expert in dissents in cases, though I hope I wouldn't have dissented in Mabo. The one dissentient was Justice Dawson, a very fine judge of integrity. And if I had been asked to write the dissent, I would have gone into a corner, got a lot of paper, started writing and saying, the law that is in question here is land law. Land law affects the property, the wealth and happiness in life of the people of this country. The law that we are asked to re-express is a law that has been expressed by the Privy Council in London on a number of occasions. It's been expressed in the High Court of Australia, supporting what the Privy Council has said. It has stood this way for 150 years, and to change it involves not just a change of some legal words on paper. It involves very complex questions of policy, of economics, and it's not something to be messed with by lawyers and judges whose life's experience has been narrow, and if it is to be done, it should be done by a Parliament of Australia, and it should be done with consultation with economists anthropologists, and with legal policy people to determine whether recognising Aboriginal title was something that should be left to a parliament informed by royal commissions. Now that would have been my decision, and essentially Justice Dawson said something like that. So it was a decision, and this is the important thing for the barristers in this room and those who are of MKC to keep in mind. In our system, decisions are often very difficult, and by the time you get up to an intermediate appellate court, or especially to the High Court of Australia, they can often be argued with great power in both directions. But the judgment that is required is the judgment of the direction that should be taken in the particular case. And it was in soundness of judgment that Gerard Brennan was famous, and rightly so. In order to overcome 150 years of land law as a judge, he had to find a key that would unlock the door to the reconsideration of the land law relating to Indigenous people that I've just described. And he found that decision in a principle that had only then been articulated by a number of judges in the Bangalore Principles. And the Bangalore Principles said that it was being increasingly recognised throughout the world that to deal with gaps in the common law, or to deal with ambiguities in the common law, or ambiguities in statute or in constitutions, it was legitimate to make reference to and be guided by the universal principles of human rights. And so Justice Brennan found his key, and in 175 CLR 1 at 42, I've read it so many times, he has this wonderful passage in which he says that international law of human rights does not necessarily be or become part of the law of Australia. It normally will only do so when a parliament in Australia brings it into force as part of our law. But in some cases where our law is in breach of universal standards of human rights, we have to reconsider it, and the judges have the authority in common law cases or in ambiguous statutes to draw upon the wisdom of the whole world community and the world of the Universal Declaration of Human Rights, and that is what he proceeded to do. And in that passage on page 42 of the Reasons for Judgment of Brennan J. in Mabo, he says that the one principle that is absolutely clear in universal principles of human rights is that you cannot have a rule of law which is incompatible with the dignity and equality of people of different races. The one principle of universal human rights which is forbidden is to discriminate between people on the grounds of race. And the land law and the refusal to recognise native title in Australia was such a law. And we had been waiting in Australia for 150 years. We're one of the oldest parliamentary democracies in the world, which is strange for such a young country, was to change the law on land rights, and that's what Mabo did. I often tell law students that in dealing with problems in the law, often the best lawyers are tax lawyers, because they know how to get a case together and call on the technical analysis of the law and find those keys in order to improve the law and to re-express it sometimes in ways that protect fundamental and universal principles of human dignity and human rights. And that's exactly what Gerard Brennan did. And that is the challenge that I hand out to the members of MKC, present, future, and extend to them the helping hand of one who is now at the end of his career but looks back on the lessons learned. The lessons learned include courage where it's justified, a willingness to change and to keep an open mind, but to get up out of your seat and walk out of the room if there is a question of integrity and doubt, and to uphold the principle of the independence of the judges, which was very dear to Gerard Brennan's heart and to his life. He died only weeks ago, and I went to his Requiem Mass at North Sydney, St Thomas's Church at North Sydney. I sat there listening to the Catholic Mass and thinking of Gerard Brennan, a true son of his beliefs and of his church and of the Christian beliefs, and of how he had endeavoured in his life, where it was proper, to bring down innovative decisions that respected human dignity and human rights. And I am very proud that he called me friend, and I'm very honoured to be asked today, on the occasion of the opening of Chambers in my name, to remember him and to bring him to your memory, because he is a great Australian. Now, many people have said to me, yes, but where is this MKC? Where are they? And remembering what Justice French said about the bar being a metaphor, I remembered what Churchill has said: I cannot tell you of what will become of Russia. She is a riddle wrapped in a mystery inside an enigma. And that's what the MKC is. It's a riddle wrapped in a mystery inside an enigma. But the basic concept is to bring together people who share a common aspiration of justice, humanity and human dignity in the law, and they will have their rooms and their offices, but they have a common commitment to very high values. Now, I have to say, looking back on my own life as a barrister, I learned a lot from being in Chambers. I learned a lot from being in Chambers with other colleagues who were very impressive. They taught me those funny little rules we have in our profession, including rules which are often not understood and sometimes not observed. For example, that when the oath or affirmation is being administered, you stand in your place and you do not move around the courtroom, and you stand silently for that moment to emphasise the importance of truth-telling to the judicial process. And the little rule, you never leave the bar table empty. You don't leave it empty as a symbol that the bar is there to help the judges and to help them get on with their cases. On my very last day as a judge, I was sitting in special leaves in Melbourne. Now, Melbourne, I have to tell you people from Perth, as I have to tell people from Sydney, is the most conservative, proper, dignified and rule-observing place in Australia. They're rather like the English, really. But on that last day when I was sitting in Melbourne, I looked down at the bar table and it was empty. And I said, I never thought that on my last day sitting in Melbourne that I would be sitting on the bench of the High Court of Australia and the bar table would be empty. So I will adjourn now until members of the bar see fit to occupy the bar table. And I did that, and that corrected it. But that was something I'd learned as a young barrister, and that's the sort of thing that you learn by dialogue in chambers. And I hope that the MKC will provide such dialogue and encouragement, and that the bar table will never be empty, and that no one will walk around the court during the administration of the oath. So I launch the MKC. I express congratulations to those who formed it, especially Greg and other colleagues, and I look forward to keeping in touch with this innovative idea, a riddle wrapped in a mystery inside an enigma.
I should point out that when I was looking through the many things which are said about Michael Kirby, one of the things which attracted my attention was the fact that he started out as an articled law clerk in what was largely what's now called a personal injuries practice. He set up his own practice for a short while as a barrister and solicitor, then went to the bar before becoming the youngest judge ever to be appointed at that time at the age of 35, and then had a very long judicial career, as you all know. And included in that career, of course, was a period of time between when he was appointed in February 1996 to the High Court, when Sir Gerard Brennan was then the Chief Justice, having been appointed the previous year, and remained as a brother judge with Sir Gerard until Sir Gerard's retirement in May 1998. And hence, in addition to what else His Honour knew of Sir Gerard, before getting to the High Court, they of course had a very close relationship as brother judges on that court. I thought the most poignant sentence in Sir Gerard's decision in Mabo No. 2 was this, which parallels what His Honour has just said. No case can command unquestioning adherence if the rule it expresses seriously offends the values of justice and human rights, especially equity before the law, which are aspirations of the contemporary legal system. I think it was that principle which parallels what Michael Kirby has just said, which led him to the decision he did in that case. But I also noticed when his son, Frank Brennan, was giving his eulogy recently, he drew attention to Sir Gerard's dissenting judgment in Marion's case, which was a 1992 case concerning whether the court should sanction non-therapeutic sterilisation. And in that dissenting judgment, Sir Gerard said this: "The law will protect equally the dignity of the hale and hearty and the dignity of the weak and lame, of the frail baby and of the frail aged, and of the intellectually able and of the intellectually disabled. Our law admits of no discrimination against the weak and disadvantaged in their human dignity." And that strikes me as a principle which Sir Gerard played out throughout his career. I'll just share with you one anecdote, a white knuckle moment which concerning Sir Gerard Brennan, which the plaintiffs in Mabo No. 2 had to endure at the commencement of the hearing of the argument of the case in 1991. A message came via the High Court Registrar, Frank Jones, who was always very kinetic with counsel in the High Court, that Sir Gerard was proposing to make an announcement at the commencement of the case. because he acknowledged that it was a matter of public knowledge that his son, Father Frank Brennan, SJ, had been actively engaged in the support of Aboriginal people, and he was proposing to invite any party who wished to do so to raise any objection they might have to him hearing the case on account of any perceived bias. He entered the court, the announcement was made, others gripped the bar table with white-knuckled hands, waiting to see whether anybody would stand, holding my breath. No counsel rose to raise any objection, and the hearing proceeded. History could well have taken another turn if something else had happened. Thank you, Michael, for your kind words today, your encouraging support of our chambers, and I thank you all for attending to this official opening of Michael Kirby Chambers.